All rise. Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to the United States Constitution and its Constitution.
Please be seated. Welcome to the First Court of Appeals. We have one case on the submission docket today, case number 0123-00043CV, the State of Texas and NPT Associates versus Laboratory Corporation of America Holdings, DBA Laboratory Corporation of America. We have appearance of counsel.
Your Honor, Philip Weinberg of the State of Texas, and joining me at the council table is Mr. Brian Vanderzin.
Thank you.
Good afternoon, Your Honors. Rajiv Matreja from Jones Day, from the appellee. With me is Kirk Talbot, also from Jones Day.
Thank you. And you've reserved time for rebuttal.
Your Honor, if I may, I'd like to open with 12 minutes and have 3 minutes for rebuttal.
Do we have that? Perfect. All right. And if anybody goes over in time, because this is a relatively complex case, the other side will get reciprocal time to make sure that everybody has a full chance to be heard. So you may proceed, Mr. Weinberg.
Good afternoon, and may it please the court. This case involving the Health Care Program Fraud Prevention Act comes to this court from a final summary judgment rendered in favor of the defendant movement LabCorp against the state of Texas, ostensibly because the state cannot show the materiality of its best price regulation pertaining to LabCorp. This judgment is wrong for two main reasons. First, the text and context of the statutory provisions at issue in section 36.002 of the Human Resources Code do not require proof of materiality to establish a defendant's liability. Second, assuming for argument's sake that those provisions contain a materiality requirement, the state raised a fact issue regarding materiality under the multi-factor approach created by the United States Supreme Court in the Escobar case.
So if we decide your way on issue number 1, we don't have to reach number 2.
That's a little complicated, Your Honor, because this is a final summary judgment. There is a provision in the sections at issue here that talks about a misrepresentation of a material fact. So we would have to show materiality as to a misrepresentation of a material fact or a half-truth. So I think that...
So has the state in its petition alleged both false statements and misrepresentations?
Yes.
What is the difference between a false statement and a misrepresentation?
A false statement is a misleading, let me take the second one first. A misrepresentation of a material fact is a misleading omission, a half-truth. It is something that is true so far as it goes, but it creates the wrong impression in the mind of the person receiving that information. A false statement, on the other hand, is something that is affirmatively false. It's an affirmative misstatement. It is a literal lie. So you can have a false statement and it not be a misrepresentation.
So we have two categories, false statements and misrepresentations. And it seems that subsection 1 has 3 separate modifiers. Knowingly, now does that apply to false statements and misrepresentations?
Yes, yes.
By virtue of its place at the start of the clause before the verb, knowingly making or causing. And then another qualifier is to permit a person to receive a benefit or payment, et cetera, not authorized. And that applies to both of them, does it not?
The to permit and everything that comes after that is basically the causation aspect of that provision. So it's telling the reader that there must be a knowingly false statement or a misrepresentation of a material fact, a half-truth, that causes a person to receive an unauthorized benefit or a benefit that is greater than one that is authorized.
And this is where we sort of get a distinction of why it's not like common law fraud. It says My reading of it is that the statement, the false statement or misrepresentation, to permit a person to receive a benefit does not actually require that the person have received the benefit.
Your Honor, the way that the state interprets this provision is we have to show that the false statement or the misrepresentation of the material fact caused a person to receive a unauthorized benefit. So yes, they have to receive the benefit.
So we can read to permit as causation, basically. Is that your position?
That's basically the way we
Mr. Lineberger, how about with respect to section B4? Because it does not have the modifier that we're talking about, to permit. That's a little bit different. And so when we're looking at section B4, to the extent that you're arguing that to permit is the causational factor, that word or that phrasing is not in B4. So how do we look at false statement or misrepresentation in the context of section B4?
That provision states that it's an unauthorized act for a person to knowingly
I'll help you out.
cause to be made, induce, or seeks to induce information concerning,
It talks about concerning information required to be provided by a federal or state law.
correct.
So it's not a false statement or misrepresentation to permit the payment of an authorized payment or payment greater than that is required. It's just the provision of information. So a better question is, do we interpret, according to the state, section 1 similar or the same as section 4B?
Well, 1 and 4B both have the false statement
Correct.
or misrepresentation of a material fact. Our friends on the other side are trying to impose materiality as to
Correct.
the false statement.
So for
provision.
concerning, so is the word concerning then equivalent to causation, like to permit in number 1?
Concerning, it's just a modifier telling us about information. And what is that information? That information has to be about, non-compliance with federal or state law, rule, regulation, or provider agreement. So, for example, in our case, here we have, our allegation is that they made false statements with regard to their provider agreements, and that is enough to impose liability. We do not have to show that those false statements regarding their provider agreements were material.
So you're going back to causation. So your argument is, if I understand it, is that there's a causation component in 1, but not in 4. Did I
1
understand it correctly?
and in 2, there also has that permits language.
Right. So 1 and 2 causation are not.
And the reason I focused on that is because my friends on the other side are trying to import a materiality provision, particularly in subsection 2, through the word permits, that permits. And that permits is really a causation element. It's not really materiality.
So it seems to me that under this reading, that you're espousing, that any statement that is violative of subsection 1 is also violative of subsection 4. Because subsection 4 doesn't require that any payment have been made. It just requires a false statement or misrepresentation, setting aside materiality for now. So what type of statement would violate number 1 but not number 4?
Well, 1 would be, for example, filing a claim that, let's say you file a claim and affirmatively state, we did not, we complied with the best price regulation. That would be a literal lie in that claim. But under 4, let's say you have a provider agreement and you make a false statement in your provider agreement that you will comply with federal and state laws regarding our regulations. So they're two different things. One is about claims, and 4 really, under our theories, are about their provider agreements.
How do you respond to the argument that subsection 2, the use of the word permit in itself inherently implies materiality?
Yes, Your Honor. the plain, if we, the definitions that they're trying to use to import materiality in subsection 2, which doesn't use the word materiality, so they have to find a way to kind of smuggle it in. They try to smuggle it in through the word permit. And permit, and they point to dictionary definitions, but those dictionary definitions don't include the words material or materiality. And furthermore, if you look at that would be a strange way for the legislature to try and get a materiality requirement when the legislature could have just used the word material in that provision.
Well, but
they didn't.
Isn't it implicit though, when you're knowingly concealing or failing to disclose information that what permits a person to then make a payment, their point is that it has to be a representation or a mission that matters, right? That is material in some respect, so much so that it induces or permits the payment, or the unauthorized payment in this case.
Well, there we're getting into causation again. The non-disclosure is causing this them to receive an unauthorized benefit. But the
So to make
best
sure I understand what you're saying. So they're making the wrong argument is what you're saying. This is not a materiality question. The question is, once that omission was made or the false misrepresentation was made, did that cause or did that result in the payment?
Right.
And so that's the issue you're talking about.
Right. It's not the word material or materiality literally isn't there. But the best. I'm sorry.
I was going to ask you a follow-up on that. I apologize for interrupting you. So everyone agrees that the language of the statute's not ambiguous. It's unambiguous language. The parties, like for a contract, just ascribe different meanings to the unambiguous language of the contract. In that situation, a court can't look outside the contract to ascertain the meaning, but we can look for things outside it, such as case law and other statutes, to provide context, to illuminate or inform the meaning of the statute that's unambiguous. Are there other cases from other jurisdictions or other statutes, federal or state, that support your position?
Thank you for that question, Your Honor. And I understand Your Honor's question to be asking about context.
Yes, the context.
The context. And here, the context, the legal the plain language and the legal context indicate that, we're talking about subsection 2 here, does not indicate materiality. Now, they want to import materiality through the word permit.
Well, I'm talking about subsection 1 and 4.
But here in subsection 1 also uses the word permit, just like subsection 2 does. So if we follow the rule that the legislature intends for the terms to have a consistent meaning throughout a statute, then permit in 1 would also have to imply materiality, but it also, the legislature used the word material there. So that would be a useless surplusage. And we don't assume that the legislature intended a surplusage like that, to do a useless act. So that is that legal context, and I see my time is
No,
up.
you
May I
can
finish
keep
my
going
answer?
past the red light. So,
But
because you're answering the question.
to just finish my answer, it's just simply if we look at these provisions in their statutory context, that it just doesn't make sense for permit to imply a materiality requirement, because then you would also have to do it in 1.
And that's but you're talking about 2 right now, right? So
2, but also 1, you would not imply materiality through permit in 1 because it already uses material.
Okay.
Yeah.
So how would you define material misrepresentation?
Well, I would define it as is how the Act defines it. And that's basically influence or capable of influencing.
Right. So if the misrepresentation causes or permits the receipt of a benefit not authorized, is it
That's
material?
causation.
Separate. So let's say it did. Let's just say the statute did not say material fact, and it just said false statement or misrepresentation to permit a person of a fact to permit a person to receive a benefit. So how can I, what I'm trying to wrap my head around is how can something, a misrepresentation be immaterial, but still lead to the payment of an unauthorized sum?
I gave an example earlier, like a false statement. If you literally lie about something and it allows you to get a payment.
Right, but let's say you have a misrepresentation of a fact. So how do we know it's material? Well, we only know it's material if it has an effect.
Let me try and explain it this way. There's a reason why the legislature used misrepresentation of a material fact. And the reason they did that is because that is, the legislature is telling the reader that this is a half-truth. And as I mentioned earlier, it's something that is true so far as it goes, but it creates the wrong impression in the mind of the
Right.
listener. And the reason you have to put a materiality requirement in there is because there is a norm that the literal truth is usually enough. And so by adding materiality, you prevent a half-truth from swallowing the rule, the norm that the literal truth is enough. It's got to be a material.
But if misrepresentation occurs, I mean, if the tree falls in the forest and nobody hears it, misrepresentation is made and no action occurs, isn't it sort of by definition immaterial?
I'm sorry, could you repeat
So
the
it just-
question? I'm having a little trouble following there.
If a misrepresentation is made, a misrepresentation of a fact, and it does not cause an unauthorized payment, how can we say that that misrepresentation would be material? It seems that every misrepresentation that allows an unauthorized payment is by definition material.
Let me try and answer Your Honor's question this way. I'm really not trying to push back here, but I'm just saying that if we take out material from a misrepresentation of a material
Right.
fact, you just have a misrepresentation of a fact, but that doesn't cause an unauthorized benefit, there's not going to be liability, regardless of materiality or immateriality.
Okay, so you're saying the second half of the second 2/3 of that section is in fact causation. There actually has to be an improper payment made.
Yes, there has to be they have to receive a benefit or payment that is not authorized, or one that is greater than one that is authorized.
So the knowing making to permit does not have to do with the intent, but rather with the tangible effects of the misrepresentation.
Right. And the reason material is in 1 and 4 is because it's talking about half-truths. And you don't want a half-truth to swallow the norm that the literal truth is enough, because then you could get away with half-truths. And you could say, we performed all approved testing, where the speaker knows or intends to convey that we performed all, let me put it this way, not approved, let's say appropriate. We performed all appropriate tests, where the speaker intends by the word appropriate to mean we performed all tests that are required by law. Okay? But if the speaker also knows that those test results were worthless, and that the test itself was defective, and doesn't tell the receiver of that information, they could get away with it because you don't have materiality. It would definitely be material to the receiver of that information to know that the test results were worthless. But literally, it's true, because we performed all tests required by law. So it's that half-truth aspect. That's why the materiality requirement is there. It's not true with false statements. And that's why you don't want it to modify false statements. A literal lie is enough. We performed all appropriate tests, where the speaker knows they didn't perform all appropriate tests. That's enough. Materiality's got nothing to do with it. And they received an unauthorized benefit based on that lie. I see I'm way over my time, but if the court will just indulge me, I just want to make my second point that I was going to put in my opening. And I won't go into it, I just want to state what it is. And that point is just simply assuming for the sake of argument that those provisions that we're talking about contain a materiality requirement. The state raised a fact issue in this case regarding materiality under the multi-factor approach created by the United States Supreme Court in Escobar. And I don't know if my time, I've gone over my 15 minutes now. Will I still have some rebuttal time?
You'll have rebuttal time.
And maybe with the court's indulgence, I could maybe talk more about it at that time.
Mr. Matreo, you'll have an additional 5 minutes of time.
Thank you, Your Honors, and may it please the court. I think it's helpful, Your Honors, to start sort of where my friend on the other side left off in his hypothetical about someone who made a representation and didn't disclose something to the receiver of that information. And maybe that could become a misleading misrepresentation as a result. Here, what we have, what LabCorp did, was fully disclose what its billing practices were to the state in 2014, combined with the granular claims data illustrating what those practices were. There's no dispute that the claims data that LabCorp provided to the state and what LabCorp told the state its billing practices were reflect what the state now contends 7+ years later is actually a long-running, decade-plus fraud. Yet, throughout that time, the state continually paid LabCorp's claims without complaint. And that demonstrates on this record that the alleged violations of the billing rules at issue were not material. And I think the text of the statute, the 3 subsections at issue, shows that materiality is required.
Mr. Matrosha, I'm following what you're saying, but as I was reading the brief too, it seems to me that what the argument that you're making sounds more to me like waiver rather than a materiality argument. And that is because the state paid for 7 years and accepted the claims and paid them, they in essence have waived their right to seek penalties under the statute. That seems to me a little bit slightly different than the materiality argument. And even going as far as reading the materiality argument in the brief, Escobar does not seem to go as far as LabCorp suggests in imposing a per se immateriality finding when there is continued payment under the statute. So can you walk us through that and explain the difference between waiver and the materiality argument that you're making?
Certainly, Your Honor. And there may very well be a waiver argument here as well, but I think it's a materiality argument, first and foremost, and certainly as we've argued it. And important to that is that we are not suggesting that continued payment is a per se bar. There would be circumstances, I think, where the state could continue to pay claims, yet nonetheless have a record on which the alleged violation was in fact material. And the state, I think, even nods at some of those possibilities in its papers by suggesting that, sometimes you might need to continue to pay claims because, citizens need the services and you don't want to cut that off. There are plenty of things that the state could do to register its view that it believes that LabCorp was billing improperly. It could have created a record on that exact point. We don't think we can stop paying LabCorp because of the importance of these services. It could have commenced administrative enforcement measures, prepayment review, post-payment review, prior authorization. The Texas Administrative Code lays out lots of options.
You say all these things here, but where in the statute are they required to do that? So basically, whether we determine a waiver or a materiality or selective enforcement, it's all you're talking about the same thing. What we have is a comprehensive statutory scheme that does not necessarily admit of what are essentially common law defenses. Where in the statute does it say that waiver of any of these things, that failure to enforce it at a given time prevents enforcement in the future?
So what the statute says is with subsection 1, you need a false statement or misrepresentation of a material fact to permit a person to receive an unauthorized benefit. Similar language in subsection 2, without the word material, but an omission that permits a person to receive an unauthorized benefit. Subsection 4b, again, referencing the need for a misrepresentation or false statement of material fact. And so the word material in subsections 1 and 4b and the word permit in subsection 2 all capture the idea that whatever is allegedly misrepresented needs to have made a difference to the state's decisions to pay the claim. And the word
How do you
permit-
answer the I'm sorry, just
Sorry,
how
go
do you respond to the argument that it's not a materiality question, but a question of causation? Did the false representation, did the false statement or misrepresentation cause the unauthorized payment, permit? So it's not really materiality, is there a causational relationship between the statement and the misrepresentation and the eventual payment of the claim?
So I think certainly LabCorp may have a causation defense here as well, but to my mind, it actually affects materiality as well as causation. I think materiality is required by, again, the text of the statute. And taking a step back, separate from just the word whether something is material or not, what the statutory text says is it has to be something that actually permits you to receive an unauthorized benefit. And when the state has knowledge of what the alleged wrongdoing is and chooses to pay the claims anyway, well then the fact that there was a violation is not really something that was permitting anything. The state had awareness of.
Go on.
But doesn't that argument then support the state's position? You don't need materiality if you make a false statement, because if that false statement by itself leads to the payment of an authorized statement, then that's what cabins the section from being as broadly applied as LabCorp fears. In other words, it's not enough to make a false statement. That false statement must have resulted in the unauthorized payment. And therefore, we don't need materiality. It's in essence established once the unauthorized payment is received based on a, quote, lie, as the state argues.
So certainly that defense might be there under the state's reading of the statute, but I don't think that's the right way to read the text of the statute, Your Honor, for a couple reasons. So one is that differentiating between false statements and misrepresentations, and the suggestion that only misrepresentations need to concern material fact, I don't think that's the right way to read the text, because what the text of the statute says is that you're liable if you make a false statement or misrepresentation of a material fact. What the text does not say is that you're liable if you make a false statement or a misrepresentation of a material fact. There's the determiner, an article, that's missing from before misrepresentation. And typically, when the legislature inserts an article or determiner like that, that's when you would take the phrase of a material fact and confine it to just the second category. And if you look contextually at the statute, subsection 2, which is about omissions that permit, the state's view is no materiality is required there. Yet the state's view is that misrepresentations do require materiality. And I think that then becomes a very odd posture where misrepresentations and omissions are sort of two sides of the same coin. Even as counsel was describing it, a misrepresentation is often something that's misleading because it omits something. So it could be an omission as well. It's hard to make sense of a scheme where omissions don't require materiality, yet misrepresentations do. Yet that's my friend's position here. And I think at best for the state here, maybe we are dealing with ambiguous language. We certainly think it is unambiguous in requiring materiality. But I think at best for the state it is ambiguous. And as the Texas Supreme Court made clear recently in the Maloof case, the rule of lenity applies to this statute and requires that ambiguities should be construed in the defendant's favor. And I think that, as a result, means that even if perhaps the state has offered a reasonable construction of the statute, I don't think they have, respectfully, but even if they had, LabCorp's reading should still prevail, and the state's understanding, the trial court's understanding of the statute should be affirmed.
Let me ask you a quick question. I'm going to go back to the discussion a little bit ago about, you were talking about that the state had made payment, and so therefore they couldn't show material fact. And there was a discussion about, are you making a waiver argument? my question is, I sort of see it a different way. Or let me ask you this, let me ask it a better way. Is your argument that it was their burden to show material fact in order to show 1 or 4, and that they just haven't made their showing, or are you in fact making a waiver argument?
We are not making a waiver argument, Your Honor. Our position is that it is their burden to establish the elements of liability.
And that they didn't make it, and that's your argument?
That's right. That's right. There may very well be other arguments that come out of these facts, whether it's waiver, causation, other things, but materiality was what we moved on and what the trial court correctly granted.
And that they had the burden to show, is your position?
That's right, yes.
Just so we understand, walk us through the map. If we agree with LabCorp's position that there is materiality required for both false statements and misrepresentations, where does that leave us? You're saying there's not a per se immateriality finding based on continued payment. So would we then remand to the court to determine the issue of causation and all of these defenses that you've said that potentially may be raised below?
I don't think so, Your Honor, because the trial court's grant of summary judgment reflects that the record has no evidence to support the state's position that the alleged violations here were material. So the continued payment that we have, which, looking at the Supreme Court, U.S. Supreme Court's decision in Escobar, is described as strong evidence or very strong evidence of a lack of materiality. We're not suggesting it's a per se bar, but there needs to be some evidence on the other side to overcome that. And there's literally nothing in this record on the state side.
So are you saying that you raised a no evidence point on that issue?
Well, no, we did submit evidence. So the evidence that's in the record all points to a lack of materiality.
But I'm sorry, I just want to make sure I understand. The evidence that you submitted, LabCorp, in support of its motion for summary judgment, was that there was no materiality because of the continued payments. My question is that if we don't agree with you that that continued payment by itself established materiality or not, what is there left? In other words, we agree with you that there is a material component to false statements and misrepresentations. We disagree with you that Escobar precludes the ability of the state to recover here because there's no per se rule. Then where does that leave us? Would we not have to remand on that issue of materiality, not based on Escobar, but based on the disposition of the case, if it were the way I just stated it?
I don't think so, Your Honor, because the state did not put in any evidence to support its view that actually the alleged violations were material, notwithstanding their continued payment. I know that the state argues that the grant of summary judgment was premature. They should have been entitled to more discovery on the issue. But it's not anything they ever requested in the trial court, whether under Rule 166A or Rule 252 to say this is premature, we need more discovery. And in terms of the materiality of these issues, that's also not even an issue on which I think the state really should need discovery. It's an issue that would turn on the state's information that the state would already have on what it thought about these violations, supposed violations, when they were happening. And did it actually think these made a difference or not? Or not really, and did they just pay the claim anyway? That's not a topic on which the state needs discovery.
Can I ask a clarifying question about your argument on Escobar?
Sure.
So if I understand, and correct me if I'm wrong, so you're not arguing that Escobar stands for that the payment constitutes lack of material fact as a matter of law or per se. You're arguing that, if I understand your argument, that that stands for the proposition that they just have put on no evidence of material fact. In that case, sort of demonstrates or illustrative of that. Is that correct, or am I misunderstanding
That's
your
basically
argument?
right, that the payment is strong evidence suggesting no materiality.
Right.
It's not per se, but when you've got strong evidence suggesting it is not material, it then raises the question of what's the countervailing
So it
evidence.
goes to the no evidence analysis or lack of evidence for summary judgment from the court. No material fact.
There's no evidence that the state supplied to create a material fact on that. And I'd add, I'm sorry.
I want to make sure I understood that correctly.
And I would add that it's not exactly surprising to me that this is alleged violation that doesn't seem to have made a difference to the state in its payment decisions. The state dictates the price it will pay for these services. It unilaterally has a fee schedule or it chooses what it will pay when services are provided to Texas Medicaid beneficiaries. So, it's not a surprise to me that they may have concluded that they saw the law differently than LabCorp did, but it wasn't the sort of thing they were actually going to stop payment on or otherwise take any action against. That may be, but what that means is that the alleged violations are not material and not the basis, not the possible basis for a fraud claim with all of the draconian consequences that the TMFPA can impose. And I think that's an especially important principle to have in this statute, because under the state's view, there is no statute of limitations here. There are no equitable defenses. And so if the state were right that its continued knowing payment of claims, even though there are alleged regulatory violations, that they can come along and file suit 7 years, 10 years, however long later after the fact.
Is that prohibited in the statute?
For them to wait that long?
Right.
I don't believe it is when the state is proceeding. Private parties.
Right, so let's say there's no white paper. There's no claim notice. Could the state have waited until 2030 to seek reimbursement, seek a remedy for those the payments that were made?
So I don't think so without the white paper, Your Honor, because there still was a meeting with the state.
I'm asking you to assume
no
white
disclosure
paper.
at all.
Right.
So if there were no disclosure at all,
Right.
I think certainly the materiality arguments we would have would be very different.
Right.
We would need to understand what exactly the state knew and when, and how did it react to the alleged knowledge of the violations. So, I think
you're not actually saying that it's a materiality issue. You're just saying it's not a false statement or misrepresentation at all.
Well, certainly that is our position. Our position, and as again we made clear to the state in 2014, is that what LabCorp is doing is billing Texas Medicaid entirely correctly, and we explained why we thought that. The materiality argument is, even if the state disagreed, even if the state had the view that LabCorp was doing it incorrectly, that didn't make a difference to the state's payment decisions. And if the state...
What if hypothetically it just took the state 7 years to figure out that it was improper? I mean, it's a large bureaucracy, decisions take time. I mean, when the case started, it was probably it was only like 5 years in the past. So it took some time for the state to realize that indeed LabCorp's billing procedures were incorrect.
Right. I think that would be purely hypothetical, Your Honor, because what LabCorp said in 2014 and in 2015 is, to a T, exactly what the state alleged is a problem in 2021.
Right.
There's no gap between what was disclosed and what was ultimately alleged. And insofar as there might be
Did
some...
they issue an opinion? Did anybody seek an opinion from the OAG's office or from the Department of Health and Human Services or anybody that this was proper?
They did. LabCorp met with those individuals. They met with HHCC.
A formal opinion-making process, formal agency determination. Did they seek that?
So I'm not sure if there was a formal opinion-making request as opposed to just a meeting to discuss LabCorp's position with the state.
So there was a discussion, no formal prosecution, the state just continued paying the claims. Now the state has realized it shouldn't have been paying the claims. How is it, is that improper? Is that prohibited by the statute? Is it either proscribed or prescribed in the statute?
I think what the statute, again, says and captures is the need for it to be material. And I think the facts that Your Honor was talking about...
I understand. I'm talking about the mechanics of that.
Sure.
I mean,
sure.
it lays out a procedure for those things. Was a procedure violated, or was there something the state was required to do to pursue a claim?
So the state has never suggested that what LabCorp disclosed was anything less than full, or that it took 7 years to figure out what LabCorp's practices were.
Well, it seems like they're suggesting it now, right?
They're suggesting
that in their...
They are suggesting it now. I don't see
Right.
anything in the record to support that view.
Well, they're suggesting that now. That is the basis of their claim, right? There is no statute of limitations or any time barring on this. So so your response is it's not material. Really what you're trying to argue is that it's been waived by, it's almost a laches argument, that they did not act on their rights and therefore everything's okay. Maybe it's just a belated determination that it was in fact erroneous. They're seeking to retroactively enforce the statute, which seems they're entitled to do if they want to.
The problem with that, Your Honor, is there's nothing that the state has put in the form of evidence to suggest that that's what is happening here. That it took them that long to determine that LabCorp was in fact violating.
They don't have to put in any evidence because the statute doesn't require, they don't need to make an excuse in advance. They don't need to put in evidence of an excuse. They follow the terms of the statute.
But if materiality, Your Honor, is an element of liability, as we submit that it is, at that point, they need evidence to satisfy their burden in the face of their continued payment. And I think they don't have that evidence here. And if they could, as a result, as Your Honor is suggesting, perhaps lie in wait for years, decades, and bring suit.
I'm not saying it's totally fair process, but I'm just trying to figure out, is it violative of the statute?
And I think it would be, taking a step back, I don't think there's any reason to think, particularly with the rule of lenity, that the legislature would ever have designed a regime like that, where the state's knowing continued
But
payment.
we're all textualists now, and we're constrained by the text of the statute and by the manual. And if it doesn't put a time limit on the state to even retroactively say its payments were improper, then how are we entitled to read a time limit into that?
So, and I don't think there is a per se time limit that would enter into the equation as well.
Well, you were hinting at that. You were certainly saying, here we are 7 years later, and they're trying to claw back these payments. So is there anything that says the state can't do that?
So I think if the state were going to do that,
Right.
it would need to have a record that would illustrate, that would demonstrate why that passage of time doesn't.
Where is that required? This is not common law fraud. This is not a laches thing. It's not brought in equity. You're saying is, doesn't that in fact say it's the longer we commit these bad acts, the longer we can get away with it? At some point you can't enforce it. I mean, it seems to me if there were improper payments made, that they should be disgorged back to the state, regardless of when they snap to the fact that was being made.
And I think where it comes from, Your Honor, in the statute is the fact that the alleged misstatements here need to have been of a material fact, need to have permitted. And so textually, I think what that embodies is the fact that when you have knowing continued payment by the state, there needs to be evidence on the state side to show how, notwithstanding that, these are still violations that matter to us. And that could come in many forms. Taking of administrative enforcement measures has happened, for example, in the Nazari case that the Texas Supreme Court cited, where the TMFPA suit was preceded by administrative actions. It could even just be the state sending a letter to the provider, to LabCorp, saying, we think you have the law wrong. We think you're billing us improperly. We're going to keep paying anyway, but just so you're on notice, we think you've got this wrong.
If that was part of the enforcement process, wouldn't the legislator put that in? Say they can only seek to call back if they've given notice to the provider.
I don't think necessarily, Your Honor, because I'm not sure I would expect the legislature to also want to force the state to take any particular route. It's open-ended.
It doesn't do a lot of things we would expect them to do, and vice versa, and not, and the reverse of that. But they didn't do it here, right? So we have to follow the procedures and adjudicate the rights as they are set forth within the statutory scheme. And they don't put in time limits. They didn't require advance notice. They didn't require pre-clearance. They don't say that if we didn't take that if the agency didn't take action earlier, it is foreclosed from ever doing that in the future. We only have the statute as it's presented, and it does not provide those defenses to LabCorp. What gives us the authority to manufacture or insert these types of defenses?
So I don't think it's manufacturing or inserting a defense, Your Honor. What I think
it's interpolating a defense that may not be in the text.
I think it's interpreting the text of the statute against the backdrop of not only the rule of lenity, there's also the common law and the federal.
We have a comprehensive statutory scheme, so I don't know if the common law actually applies here. But I do get your point about the rule of lenity that may afford some succor to you, but where in the statute? I don't see anything in the statute that allows these defenses that you're you're advancing.
Yeah, but insofar as the common law goes, Your Honor, we do expect the legislature to speak clearly when it departs from the common law. You know, Chief Justice Adams asked the question, are there any cases, anything from any jurisdiction?
Well, I was going to ask you, actually ask that question after you were finished here, yes.
And we're not aware of any.
For
We're not-
context, that supports your position.
That's right, Your Honor. We're not aware of any case, no case in Texas, no case in any other state, no federal case that actually holds that a scheme like this lacks a materiality requirement. I believe it would be unprecedented.
Is there a case, federal or state, under any statute with similar language as this that reads the statute the way LabCorp does, with material fact, applying both the false statement, applying the false statement as well?
So the cases from other jurisdictions on this issue are not dealing with a statutory regime exactly like this with these subsections, but they are False Claims Act, whether it's the Federal False Claims Act or False Claims Act in other states, which do have similar language. So the definition of material in the statute that we're dealing with here under Texas law, I think is similar to the federal definition, and there the courts have said, you know, starting with the U.S. Supreme Court in Escobar, that continued payment, it's not a per se bar, but it's strong evidence. And as we've cited in our papers, there are many examples of cases where that continued payment precludes the claim. The state does cite cases where continued payment did not preclude the claim.
But let me go back to, so are there federal cases under the False Claims Act or any other statute to help us with the interpretation of the language in the statute, in terms of, because that seems to be the big issue here, or one of the big issues here, is that material fact only pertains to the misrepresentation language in the statute, not to the language before the word or, false statement. Have any courts construed this similar statutory language to provide clarity on that, whether or not material fact applies to both or just one of those?
So there are decisions not dealing with language exactly like this, but dealing with phrases that have a modifier after a phrase, and does it apply to just the last, is it a last antecedent issue as the state argues, or does it apply to the whole series? And I apologize, I'm blanking on the specific names of those cases. They are in our papers, but that support the point that it applies to the whole collection of items and not
so
just...
we could look to those cases for context and common law, but not to construction principles, because the language is not ambiguous.
So I think those cases would stand for the general interpretive principles that would apply here. But what's I think maybe absent from those cases, but we have present here, is the rule of lenity as well, where again, if you have two reasonable constructions, the way to read it under Maloof is the version that would favor the defendant, and here would require materiality. I see I'm well over my time, unless the court has any other questions.
Any more questions?
No, I do not.
Thank you for your argument.
Thank you.
Mr. Weinberger, you have an additional 3 minutes for your rebuttal.
So 3 plus 3? Or?
3 plus 3.
Thank you, Your Honor.
Mr. Weinberg, do you mind starting off, because I do want to address one question, a good point that Mr. Matresha made, and that is in connection with section 1 and 2. The argument was that misrepresentations of material fact include half-truths. In that section, we argue, the state argues, that there is a materiality component. Yet in subsection 2, you're also dealing with failure to disclose. And there is no materiality component here. And so there's an incongruence, LabCorp argues, in treating misrepresentations and failure to disclose differently under subsection 1 and 2. Can you address that?
Yes, Your Honor. I don't believe there is an incongruity. The legislature specifically chose not to include a materiality requirement under 2. This is a non-disclosure, a failure to comply, or a failure to disclose that causes the payment of an unauthorized benefit. That is all the state has to show. Materiality has nothing to do with it.
But to follow your construction, we have to harmonize all of the words are their use in these three subsections.
Yes.
And there might be some disparity in construing that materiality applies only to misrepresentations in subsection 1, but partial disclosures or failure to disclose in subsection 2 would not require such a materiality.
Let me try it this way, Your Honor. Misrepresentation of material fact in 1 and 4 is doing real work. It's talking about half-truths, swallowing the norm that the little truth is enough. When you don't disclose something, then you are not even telling the state anything, and the state is therefore paying you.
So
there is not
partial truth versus complete failure to disclose.
there's no statement there. There's no disclosures there. That's different than
It's
1
a
and 4.
complete omission versus a half-truth is how you're parsing it between 1 and 2.
Well, let me try and make it concrete, because our theory under Section 2 is that there's a requirement in our regulations that if there are any overpayments, then you must, as soon as you know about that, you must refund those overpayments to us. Our theory is that LabCorp knows that there were overpayments, but they didn't tell us that. They just kept submitting claims without ever correcting it. And therefore, that's a non-disclosure that allowed them to keep a benefit that they weren't entitled to. It had nothing to do with them telling us a half-truth that created the wrong impression in our mind. They just literally didn't tell us.
Well, their argument is you knew for years. And so
We
that
didn't.
leads me to, I guess, my next question
Yes,
is
sir.
what evidence was there of materiality?
I'm very
at the
glad
time?
you asked that, because there's lots of evidence. What we're talking about here, what they're relying heavily on, they say we're not saying it was per se proof, but they're relying on the government action factor from the Escobar test. The Escobar test has several factors, and all those factors have to be weighed. And furthermore, they had to conclusively establish this government action factor. They didn't do that. There are fact questions regarding their disclosures at those meetings, and I invite the court, go and read. And I don't mean to suggest the court hasn't already read it, but if the court hasn't, you should read their PowerPoint presentation from this 2014 meeting and this 2015 white paper. Go read those and see if that's clear to you that they're coming clean, that, oh, we're providing discounted prices to private payers that we're not providing to the state, that are below the state's base rate.
But Mr.
And we're not giving
answers
you that same rate.
That answers the question of the state's knowledge. But what evidence was presented at the trial court level on the issue of materiality? In other words,
Okay.
did their statements persuade or permit the unauthorized payment, notwithstanding this knowledge issue?
Well, they did not persuade the Office of Attorney General, because in 2018, the Office of Attorney General issued another civil investigative demand. They were not satisfied with LabCorp's answers. And what they're learning, and what LabCorp does not say in those 2014 and 2015 presentations, is talking about what was below the state rate. Those discounts that were down here, they were talking about everything between the state rate and their usual and customary charges. They weren't talking about what was below the surface. State had no knowledge of that, and we had to do our full and thorough investigation and analyze it, which prematurely got cut off by the trial court because she stopped discovery, grand summary judgment before discovery was done. And that's what we're talking about here. They did not disclose it. So there's a fact issue on the state's actual awareness of their wrongdoing.
And what evidence did you present at the trial court to basically make that point?
I see my time is out. The evidence that we would present is the evidence that I'm just talking about, is what's below the base rate. We were not, at the time that they were doing this, we weren't telling them, I see you've got a point there. We didn't know. We're investigating, trying to discover. That is, I mean, that's just
So what you're saying is
the reality of the record.
2014 white paper was in itself a misrepresentation, a half-truth.
I don't, it did not
In
tell
effect,
us what
I'm not
was,
gonna-
yes, it did not tell us about what was below the base rate. And the last, if I may, Your Honor, just real quickly, the other evidence here, there's several other factors that the court should have weighed against this government action factor. And I'll click them off quickly so I don't impose on the court's time. But the first factor is whether this best price regulation was a condition of payment. We put in evidence of the provider agreements, the procedures manual, and we put in the affidavit of Catherine Scheib talking about how best price is a condition of payment. So that's a factor that has to be weighed against their government action factor. Another one is whether best price was the essence of the bargain between these parties, and it certainly was. It's just a matter of common sense, which Escobar says you may use your common sense. It is obvious that these violations, which we allege were amounted to millions of unlawful acts and could result in tens of millions, if not over 100 million in authorized payments. That is not trivial. It is, and the magnitude is substantial. And another factor is whether, I got ahead of myself. That is the minor and
I assume this is in the
substantial.
briefing?
What's that?
These factors are in the briefing?
They are, but not as clearly as I'm portraying to you now. But
I think we have your arguments.
Okay.
So we appreciate
thank you, Your Honor. Thank you for your
time and
patience.
efforts on behalf of everybody. Case of the State of Texas versus LabCorp is hereby submitted. And for the last time, I get to adjourn an oral argument. First court is adjourned.
All rise.